during our lifetime.
What are the rules on gifting, Sanjay?
Stamp duty is payable on an instrument which is in writing, document which is creating a record saying that you had gifted in the past.
So how do you ensure that it does stand up to that being contested?
And at least people who are bickering or who are quarreling, okay, are not that bothered because it's just 10% of what you left. Don't mingle them. Don't put
Create separate
create
trust.
separate trust for each of them. Whatever asset you want to give, do it. How much do you require?
The writer Bill Bryson has a way with words. He describes the miracle of life. In the introduction to his book, A Short History of Nearly Everything, Bryson writes that the constituents of the human body can be found in any chemical laboratory. Imagine that. The thing is, at the fundamental level, the atoms that are so invested in coming together in the unique way that makes you, decide after a certain point to disperse. Death. It's not the most comfortable topic to speak about, but it is an eventuality that we can prepare for, and we should, in fact, prepare for. For most of us, our concern is not for ourselves, but for those that we leave behind. And so, today, on MoneyWise, I'd like to find out for you how best to ensure that your hard-earned assets are distributed the way that you want. In other words, I want to talk about succession. Joining me today is Sanjay Ashar, who is a senior partner at Crawford Bayley. Sanjay, thanks so much for taking the time.
Thank you.
So let me start by asking you this. You've seen decades of people contemplating this, maybe not finally signing on the dotted line. Why, in your opinion, are people so hesitant to set up everything so that the next generation doesn't have to worry? Is it fear of death?
Maybe it's fear of death. Maybe one doesn't know that it's your hard-earned money, whether it will go to the next generation or you are leaving behind for your kith and kin, whether it would go in a timely manner, whether they will be able to enjoy, whether there will be any difficulties in implementing what is written in the will or what is your wish. Because from your grave, you cannot control anything. So how do you control it, or how do you do, or what do you do rather, a mechanism whereby you are able to effectively pass on your hard-earned assets to your loved ones? Now, will, of course, is one of the way by which you do it you can bequeath your assets to somebody whom you would want to bequeath it to. However, I would suggest the following, which is that why can't we transfer the assets during our lifetime?
Oh, that's an interesting thought. So you're saying before it gets to, and everybody talks about this, and I've had this conversation, Sanjay, so many times over the course of the last several years, the need to have a will to ensure that everything that you want to transfer goes to who you intend it to be transferred to. Because if that doesn't take place, you have nominees, of course, or your legal heirs can battle it out and say, oh, this is mine or this is yours, right? But you're saying that you don't want it to get to that stage at all. You want to distribute assets while you're still alive.
Absolutely. Now, there is a way. Now, for example, if you have an apartment or an immovable property and you want to bequeath to your spouse, or you want to bequeath that to your son or to your daughter, what you do is you gift that particular immovable property or that apartment or bungalow or whatever that may be during your lifetime with a proviso written in the deed of transfer or in the gift deed or in the deed of conveyance, saying that, look, you have the right to live in that, to use that, to occupy that, to physically possess that until you are alive, and the interest passes on only on your death. So what happens is that you have a document whereby which says, yes, I am bequeathing this or I'm gifting this particular immovable property to my spouse or to my daughter or to my son, but I will have a right to use that and to possess that until I'm alive, which is legally completely valid. At the same time, you know that there will not be any dispute post your death because the deed is a registered document.
Okay, so I have a question on this. In the process of transfer, and here we're talking essentially about real estate, physical assets when we're talking about, and the average Indian has physical assets in the form of gold or in the form of real estate. When we're talking about this deed that we're writing, does it mean that when it gets registered, there is a transference of ownership at that moment?
Yes, very much. There is a transference, a legal transference of the legal right in that immovable property. Now, which helps to avoidance of dispute at a later date. Number two, if that immovable property, for example, is in the city of Bombay, obviously you require a probate or a succession certificate. Your legal heir will not have the hassle to run after in the courts, to run after lawyers, to wait until the entire process is complete. God forbid, if there is an inheritance tax which comes in.
Which does not exist.
Yes.
Right.
And real estate prices or real estate values in the city of Bombay keep going up and up and up. Okay? Your legal heir or somebody whom you want to leave that immovable property will have to cough out, okay, a huge amount, whatever comes up in the inheritance tax. So obviously you don't want to leave an issue, a trouble for your near and dear ones to whom you intend to pass on that property to.
What are the rules on gifting, Sanjay?
Nothing. If it is an immovable property, you have to have a registered document. In other words, the document pursuant to which you are giving that particular asset as a gift, if it is an immovable property, has to be registered with the sub-register of assurances. Depending on the relative definition, there is a small amount of stamp duty as well, which is not huge amount as 6%. And at the same time, it's a foolproof mechanism. It's a foolproof document. And in case you want to get a registered document cancelled, then obviously there needs to be a court order. So in other words, what I'm saying is that the person to whom you're giving that gift, and that gift deed is registered in case of an immovable property, mind you, the inheritor gets it, or the donee, or the person receiving the gift gets that particular.
In the case of if they were doing this in the form of a will, and if there was a probate then, and if after
then
that...
there would not have been a stamp duty.
There would not be stamp duty. So that's the difference between the two.
Yes.
Okay.
Yes. But at the same time, in relation to a movable property, if you're gifting a movable property, there need not be a document.
Okay, document.
Or
right.
there need not be any registered document, or the document pursuant to which you are giving a gift.
Yes.
Does not require registration.
Yeah.
Now, if you are giving a movable property as a gift, at least in the city of Bombay, there is a 3% stamp duty. Now, obviously, you would not want to pay that huge amount of 3% as stamp duty. So what do you do? What you do is, you give the gift. For example, if there are shares in a listed entity, you transfer the shares.
Yes.
Okay? And after the process is complete, you just write a letter that, look, I have on this day transferred to you 1,000 shares of Tata Motors.
Sure.
As a gift to you towards my love and affection to you, period. And that is a document which is creating a record saying that you had gifted in the past. In the past would mean 24, 48 hours or 7 days prior to the giving of the gift. So in other words, stamp duty is payable on an instrument which is in writing, okay, conveying or transferring or passing on the title to the transferee. Here, the title is already transferred. You are just recording something that I have done it in the past.
Sure.
Now, that is not subject to stamp duty.
Right.
So, in case of, say, shares, I would say if you have 100 shares, I'm just talking at 100, you give away 80.
Yeah.
If you think that 20 is the one which you will require for your use during your lifetime or the balance lifetime.
Right.
In which event, what happens is the issue of nominee versus who is the beneficiary after your death. All those issues are
never
done away
arise.
with. Yes, and then it's only a 20% of 100 or maybe 10% of your 100 which remains. And if at all there is a bickering or there is a quarrel, it is only in relation to 10, okay, which in any event you can't control.
Yeah.
And at least people who are bickering or who are quarreling, okay, are not that bothered because it's just 10% of what you left.
That's a nice perspective. It's a very different perspective, Sanjay, to what I must confess I have heard over the course of the last several years. But there are other ways, of course.
There are other ways.
There are other ways. Let's talk about that in some form, because what you were suggesting also while I was talking to you in the run-up to this conversation was that rather than only doing a will, why don't you do a trust structure along with a will? Why would you suggest that, and what does it entail?
Sure. See, you can create a trust structure. Now, if you have, say, 3 immovable properties, you have spouse, you have 1 son and 1 daughter, in which event you create during your lifetime 3 different trusts.
Okay.
You actually transfer the 3 immovable property in the trust, okay, whereby you are the primary beneficiary, your spouse is the secondary beneficiary, and your tertiary beneficiary, okay, is say son 1 or daughter 1. So that what happens is that there is no mingling of the beneficiaries. Each beneficiary has his own trust, okay, and immediately on the secondary beneficiary not being there, the tertiary beneficiary becomes then the primary beneficiary.
Okay.
So there is no bickering amongst, or there is no fight, or there is no quarrel in relation to that particular property.
Okay. So the ownership in this case, I'm trying to understand, is already shifted in your lifetime
during
to the
your
trust.
lifetime to the trustee.
Yeah.
Okay. And you are the beneficiary, the primary beneficiary during your lifetime.
Sure. And so along with that, you're saying you need to write a will. So what is the process of that transference? Is there a...
There is a document, there is a trust deed.
Yeah.
And in case there is an immovable property, then that trust deed has to be registered so that the trustees get the legal right title interest in the immovable property.
How do you, and where do you get this document? Which court do you go to?
No, you have to get it done with the sub-register of assurances.
Okay.
Just where you get your property documents registered.
Right.
Okay. Now this is in relation to the immovable property.
Okay.
There is also movable property.
Yes.
Okay. There also, whatever you want to give, okay, you give it again through the trust mechanism. You are the primary beneficiary. Secondary beneficiary is your spouse, and the tertiary beneficiary
is your child.
Your child.
Yeah.
Okay. So what happens is 100 shares of Tata Motors. Okay. Then on your death would go away to your spouse, and thereafter it goes away to your son.
Without a will as well.
Without a will as well.
Right.
Without a will as well, because you are creating what they call it as inter vivos whilst you are alive, and you are putting that particular asset in the trust. From your ownership, it gets into the trust ownership or the trustee's ownership, in which event, at least there is no, again, quarrel or bickering after you are not there, because it's not a will. A will is a document which can create dispute, which can create quarrels and bickerings.
So a couple of questions here, Sanjay. When you've created a trust, you are the trustee ultimately, right? And then there is a...
Along with you, there would be 2 more trustees. So you appoint 2 more trustees as well.
Okay. Is there a limitation on how many minimum people you need to have in a trust?
No. So you usually create 3 trustees.
Sure.
So that what happens is the voting becomes 2 versus 1.
Right.
And it does not get into a deadlock situation.
Right.
In the trust document, you elaborately write down whatever you want to write down.
Yeah. So you have conditionalities you can put in.
Yes. Now, the beauty of that is only if you are creating and you are transferring everything during your lifetime. It should not be that, look, you are leaving it in the will that this asset will go into the trust after you are no longer there. As opposed to you are transferring whilst you are alive. That's a difference. There's a stark difference between you are transferring anything to a trust whilst you are alive, as opposed to you are writing in the will that, look, it will go to a trust of which ABC would be beneficiary, so on and so forth, which can create disputes. So the cleaner way of doing that is that do it during your lifetime, transfer the asset into the trust, settle the assets. They usually say settle the assets in a trust, and in case you have more than one beneficiary after your death, then you create don't mingle them. Don't put
Create
more than,
separate
create
trusts.
separate trust for each of them, whatever asset you want to give.
So, question here: how do you determine who should be your trustees, and um, are there drawbacks to this? Can this have a failing? Nothing is completely foolproof ultimately, right? So, is there a failing here that you need to know about?
No, there is no failing. I wouldn't say there would be a failing. It is only that managing the trust, you will have to file your tax returns.
Sure.
You will have to have your minutes of the trust meetings. You'll have to conduct the meetings, so on and so forth.
So, who are your trustees?
So trustee, you will be the trustee.
Sure.
Your spouse would be the trustee, and the beneficiary would be the trustee.
Okay. So just the
with
three.
a proviso in the trust deed that look, there can be additional trustees which can get appointed by the remaining trustees. So all that in a foolproof manner you write in the trust document, so that 99% of the eventualities are addressed. Obviously, you can't address 100 or 100 each time. At least 99%, and the legal heirs would have very little trouble once you are no longer there, and they should be able to enjoy, or they will be able to enjoy the property which you intend to for them.
Okay. So, but further question: is this the case where somebody who has a very valuable property, a very large estate, would be more beneficial? Or this would be more beneficial for those people as opposed to those people that have maybe not as much in the way of assets to disperse or to distribute?
No, I would say, because if it is a large estate, okay, then the question is, are you dividing the estate just now while you're alive and you are creating two trusts, you are demarcating that, so on and so forth. So that issues will arise. If you want to give that particular estate only to one person, okay, say for example to your daughter as opposed to your son, or to your son as opposed to your daughter, in which event fine. Yes, you write down that look, you are creating a trust in relation to this particular large estate, and the beneficiary is yourself, your spouse, and then your son.
Okay.
Okay. Now for a smaller property, for example, I'm not being agnostic on gender, but I'm just saying that look, in the second estate or the second property, you are creating another trust where the tertiary beneficiary is your daughter, for example.
Or it could have been the other way around.
Yes.
Right?
In the smaller one, the son is the beneficiary, and in the larger one, the daughter is the beneficiary. I mean, it all depends on what you want to do.
Right.
But again, don't mix, don't keep two beneficiaries in the same trust.
Okay.
That's the message. That's the point which I'm trying to make.
Okay. So this is the second way that we've discussed. The first is you distribute the assets while you're alive through gift deeds. The second is you create a trust structure, but you also write a will, I would think. But do you need a will if you've got a trust structure? It's not required.
No, I mean, that's not required, because there would hardly be. It is only that other than the trust properties which you have already created, okay,
whatever movable assets you might have,
in which you
cash, etc.
Cash, for example, or if you may have some fixed deposit and small amount and some interest accrues, etc. So that only needs to be then distributed through your will. So that would be less bothersome, or that is less hassle. And these days the question about nominee, and you do put a nominee versus the actual beneficial owner, that issue keeps coming up.
So I want to talk about this. So we've talked about these two. Let's talk about the third, which is what is most popularly discussed. And let's start with that aspect, nominee versus beneficiary, right? Because there was an exercise that was conducted a short while back by the regulator, said, please go out and nominate, and you have to either nominate or say you don't want to nominate, and most people decided to not nominate for whatever reason. What is the difference?
See, it's easy for the purposes of transfer after your death.
Yeah.
Okay? Because what happens is, otherwise it should not lie in limbo. Pending letter of administration, succession certificate, probate, so on and so forth. Okay, so which is why the regulator put in that, look, please create a nominee structure whereby you nominate somebody, so that the depository or the banks, okay, would take on record the nominee's name, and would add nominee's name pending succession. So in case you have a will, for example, At the same time, you have given a nominee name to the bank or to the depository participant, etc., in which event, temporarily, in my view, it will remain in the name of the nominee. However, if the beneficiary is somebody else in relation to your shares, nominee is not your owner, is
Right.
not the owner.
Right.
The probate, once it is obtained, you will have to go to your depository participant, to your bank, file that particular probate with that institution, with that agency, and then the agency will make mutation entries change and will change. If nominee was X, the beneficiary was Y under the will, and in which event it goes to Y.
So therefore, the nominee is essentially just a
Temporary.
temporary safeguard
Temporary safeguard, absolutely.
of the property or whatever asset we're talking about.
Absolutely. It's
Okay.
not a permanent one.
Yeah.
It's not the final one. It could be that the nominee and the beneficiary may be the same.
Yeah.
But nonetheless, the process needs to get completed.
So therefore, in the transference of asset, which can happen with a nominee, as you've pointed out, the transfer of ownership does not occur till the complete process is done.
Absolutely.
That is the difference.
Absolutely. Till the succession and the legal process of succession is complete.
And how does that get done? You need to have a probate, you need to have a will.
Will, you complete the process of filing it in the court. The court issues the letters to the legal heirs, you file affidavit, and in case somebody challenges it, it gets converted into a normal lawsuit.
So, okay, so but before that, who are the actors in this case, right? So, in what I've read is in places like Mumbai, in places like Bengaluru, there is an additional step. You need to have a probate, as you've pointed out.
That's correct.
What is the difference between that and the other normal way of going about it?
No, see, a probate, okay, in any event, to my mind, whether it is in a city of Bombay or otherwise, is required, okay, for making the mutation entries change in the immovable property registrar. In movable, nobody, or rather, quite a lot of times, the agencies do not ask for a probate. They only take an affidavit, take a declaration, take an indemnity, make an advertisement in the newspaper, and they transfer it. However, in my view, that's not a complete 100 on 100 legal process. The moment there is a will, there has to be a probate, irrespective whether the probate is required in that particular city or not.
What does it entail?
It entails filing it with the court, the probate petition, then the no objection from all the legal heirs.
Sure.
Okay.
Even if you have a will?
Yeah, of course, of course.
Okay. The other, in a hypothetical scenario, daughter has been named in the will to receive all assets.
Son is not there.
Son is alive, but is not named in the will.
Correct.
So
in which event the no objection
has to come from the son.
Yes, of course.
So, and therefore, what you're saying is, in a lot of these cases, it does get contested.
It does. 100% it gets contested.
So, how do you ensure that it does stand up to that being contested?
Look, if you see from a philosophical perspective, it's the mental state, in the sense that if a human being is there, and if your father or your grandfather or anybody has left a will behind you, okay, you respect that particular wish of that individual,
yeah,
and you don't contest it.
Okay.
Now that's a philosophical
Sure.
situation. But if you think and no, this is not correct what he has done or she has done, in which event you contest. So if you are the legal heir, you file your objection, and then in which event the probate petition filed by the executors of the will, whilst getting your no objection, will get converted into a lawsuit.
Which takes years and years.
Of course, it's a normal, it's then the normal process of a legal suit or a lawsuit,
Sure.
which gets into action.
Sure. So therefore, the question to you is, if I am doing something that is not normal, in that I'm choosing one heir over the other, what should I do to ensure that it stands up in a court of law?
I would say that the will has to be written in a very unambiguous, simple manner. That is number one. Number two, register the will, okay? So that nobody can then, or the chances of somebody arguing that, look, the signature was forged, okay, gets reduced considerably. Thirdly, these days, as I understand, even the registrar insists on a medical certificate.
Okay.
Okay, so you go to a medical practitioner, you get the day or next day when you are going to register the will, a very elaborate, detailed medical certificate. Pay that money through the check or through the credit card. Attach, I would go one step forward, attach the receipt of that credit card also with the will, okay? So that what happens is that anybody, a court, while looking at it, says, no, it's a absolutely genuine will, and the person who has written the will has thought of all sorts of eventualities and has mitigated to the extent possible, and somebody else is challenging it only because he or she has been deprived of the assets.
Basically, you need to, through that transaction, because you've gone and signed a check before, or you've entered a PIN.
Yeah, medical, nobody should
you've
then
proven
say,
your mental faculties.
Yes, yes.
And you've gone ahead and done.
Yes, and in case there is jewelry, or in case there is art work, or in case there are, say, silver and gold artifacts or anything else, in which event you go to a jeweler, you describe that, you tag it, you do it in such a manner that it has to be an idiot-proof mechanism, whereby you know that what piece is going to whom.
Yes.
Okay, rather than leaving it, okay, this much goes to here, this much goes to legal heir B, etc., etc. It has to be done in a very idiot-proof manner so that there is no ambiguity left for the executors. Because after you are no more, as I said in the preface, look, you can't control anything from your grave, nothing at all. So you have to try and leave lesser problems for your legal heirs, rather than trying to think that no, you have written a will, so everything is hunky-dory.
And a very easy and prompt solution to that is to transfer certain assets while you're alive. And
absolutely, I would say that should be the first, that should be not first but 0.9 priority, in the sense that do it. How much do you require at the end of the day?
Yeah.
Okay, and you've enjoyed it the entire life.
Yeah.
And you want your hardened asset to go to somebody whom you intend to do it.
Yes.
So you know that you've done it, and you are satisfied, you are happy, you are mentally at peace that nothing is going to happen, or very little may happen after you are no longer there.
On that note, thank you so much, Sanjay, for taking the time. Pleasure speaking with you.
Pleasure. Thank you.
We've hopefully given you something to think about. Let us know what you think in the comment section, and do stay tuned. Lots more coming up on NDTV Profit.